Okay, it is 7:14 p.m. on Monday, November the 29th, 2021. I've been on for a little while, but I've been enjoying a chat with one of my students, Valerie, who's a fellow Bear fan, and sharing some pictures of um, the Bears that Walter Payton specifically, and some more stuff. So, go Bears! I know those of you Packer people that are listening to this recording say boo. Yeah, okay, but you know, we are the Bears shuffling crew. Anyway, don't get me started. Okay. Uh, oh God. Talk about somebody funny though. I got to tell you this before I get started. Steve Fuller. I'm Steve. Steve had a real country sound, but he was a cool dude. He was really cool. I loved all those guys though. I feel bad though for Steve McMichael. He has multiple sclerosis, and he has a restaurant that's not too far from where I live right now. And yeah, he was a good guy. He's a good guy also. So welcome to Constitutional Law. Um, J331, CJL 3297, um, week number 4, week 4, week number 4. And this time I got the screen right. I can see your name and I can see myself. Yay. Thank you, Valerie. I think you were the one last week, I think, that told me I can't see it. Thank you so much. I love my students because my students help me out of some jams sometimes. So good to help an old man out here. So, all righty. So here we are. And what that means to everyone is you should be, yep, that's true. That's true. We all need help sometimes. Um, my, so I want to remind you we're in week 4. You know what that means? That means we've crossed over into the second half of the course. That means that all assignments from weeks 1 to 3 that are not in will not be accepted unless I have made arrangements with you before that, but I can't recall really anybody in this class that has happened to. This class is doing pretty good. You guys are one of my smallest class I've had in a long time. And one of the courses that I enjoy, oh man, I have so much fun talking about this course because it's like the meat and potatoes of being a criminal lawyer and a police officer. I mean, it tells you exactly some what we call fundamental tools of the Constitution, the Fourth Amendment, the Fifth Amendment, the Sixth Amendment, the Eighth Amendment. I mean, just a bundle. So we've been talking about the Fourth Amendment, search and seizure. We talked about the exclusionary rule, which was a great tool for us in previous weeks 2, and then in week 4, Fourth Amendment, and then now we're in the Fifth Amendment. Fifth Amendment has to do with self-incrimination, the famous um, case of Miranda versus Arizona, which I always get excited about talking about since I had a professor who didn't like that case because his processes were with the Supreme Court said that he had written in his book were unconstitutional and not to be used, and he took it personal. And until he died, he wrote amici briefs so that he can, or amicus briefs, whatever you want to call them. There are more than one brief to try to get that thing overturned. So let's quickly just look at the calendar. I told you that when we get after Thanksgiving, that um, today's today's lecture would be Wait a minute, what am I doing? Oh, I'm down here. I'm at the top. This is the last lecture that you'll have in November. And your initial post is due tomorrow, which is the 30th. If you say if you have an assignment due on the 31st of November, there is no way, because there is no 31st of November. Okay. Just remember my little poem that I talked to. If you've been in any of my other classes, I talked about how I won a case when it was said that my client committed a crime on the 31st of April. 30 days has September, April, June, and November. All the rest have 31 except the month of February. That's how I always remembered. I was a little kid, but it won a case for me. So my granny had passed on. If she was alive, I would have told her, I said, Granny, what you taught me as a kid, I won a case. You know, little common sense stuff is really what makes you really good. That's why I was so successful with connecting with jurors as a criminal defense lawyer. So next week, we will be starting with the assignment due Saturday, the 4th, then the 5th for the written assignment and key phrase. So next Monday will be actually, if you pay attention to it, next Monday will be the last full week that we will have, because the 17th is when class ends. I know it bores you to hear that over and over, but trust me, I have 2 students who last term, and one of them was in this class, who tried to say that they submitted their assignment at 12:01 on that Saturday, and I told them I can't do anything. You know, I cannot do anything. So, all right. So anyway, the bottom line, unless you got the incomplete appropriately and those kind of things, I don't think I have candidates in this class anyway. Anyway, all your assignments are due the 17th. We are out after the 17th until next year. No more classes until January. All right. Let's go back to look at one more thing before we get to the module. Week 4 announcement. By the way, you should have the PowerPoints that I sent you I have to keep moving this thing around. The Fifth Amendment and Government Authority, chapters 4 and 10 of your textbook, the PowerPoints. And we deal with double jeopardy. Double jeopardy. Miranda, resurrecting Miranda right to counsel is a good article. Procedural due process claims, double jeopardy, research starter, Fifth Amendment, due process of law, research starter. And so we're going to just deal with those briefly tonight as we talk about the topics. Of course, the initial post, as I said, and we'll repeat one more time, is due tomorrow night. Your reply post Saturday night. Okay. The right to remain silent. And if you don't know where that phrase came from, then you can flunk the course. But the right to remain silent. Okay. The deadlines for the written assignment, Fifth Amendment limitations, are due this Sunday, along with your key phrase. And you know my motto, adversity is a springboard to success. That's it for that. So let's dive into the Fifth Amendment, the topic. First, let's look at the written assignment. Make sure we're on the same page here. So the limitations of the Fifth Amendment, and there's a scenario that is in here. I like these scenarios that they have put together for this course. Again, my all-time favorite scenario is the one in the discussion post about the head in the refrigerator. few weeks ago. You know about that one. That's Fourth Amendment issue. And so this one is really interesting. I love to see how students will review this. So you're going to write a 3-page to a 2 to 3-page paper. It's okay if you go beyond 2, but please give me 2 pages, double space. Please don't cut it off with 3/4 of a page because I will cause you to lose points. So discuss the right to remain silent. Um, support your ideas with appropriate case law, appropriately cited. You know by now what that means. Explain, and if you don't, then say, hey, I don't know, would you help me? But I know you know. Um, explain how you would handle the demand by Jim's mother. That's all I'm going to say about that. Remember, Jim's 18 years old, which makes him an adult. I gave you that statement for a reason. Pay attention to that. That's a little biscuit, okay? Describe how you would proceed, including how you'd properly handle Miranda when you continue to question Jim after his arrest. Discuss how ensuring Jim's rights are protected is essential to procedural due process. If you've been paying attention the last few weeks, it's critical. Provide credible sources. What that means is it's in APA format. Please do not give me references in the body. Give me citations appropriately in the body and a reference page, cover page, properly formatted, okay? And correct spelling, grammar, as I have. I run all your papers through Grammarly, and you guys are doing pretty good. So you have the help right here. So let's look at the rubric. Okay, the rubric, as you know, I don't teach from this. I teach from this. So therefore, this is what I want you to learn. Right to remain silent. Outstanding discussion with the right to remain silent applies in criminal cases with comprehensive details from appropriate case law. I don't think you can do service to this without including the landmark case. Do you know what the landmark case is? Type it in the chat box if you know. The landmark case and right to remain silent. What is it? You don't have to give the full citation. You can just give the name. What's the name of it? What is it? Yeah, okay. Yeah, but it's Miranda via Arizona, and give me the full citation. But you got to make sure if I don't see that mentioned in your paper, and remember you appropriately cited the first time, full, and then you know how to cite it APA formatted after that. And so it's very important that you do that, and you might find some other things that are cases that might apply, but it's very important. Jim's mother's demand. Explanation of that. There's some case law to support that. We'll talk a little about that tonight. And how would you handle Jim's mother's demand? Comprehensive details. All right. Miranda and protecting rights. Outstanding description of how you'd proceed, including how you'd properly handle Miranda when you continue to question Jim after arrest, with comprehensive details on how you ensure his rights and procedural due process rights are protected. Credible sources, you know what that's about. and then 2 pages at a minimum, professional. Notice if you don't get 2, you're gonna lose down, you'll jump all the way over here. So some might say, well, that's only 5% of the grade. Don't think of it like that. Trust me. When you get your grade, you'll say, wow, I blew uh, those points. I could have got a perfect paper, but got to do that. All right. I think that's pretty clear. Any questions about the written assignment? Okay. All right. So now let's go to the discussion of the right to remain silent. So you're going to apply the right to remain silent to this scenario. Discuss the strategies you would use to set up a non-custodial interview. How would you ensure they remain non-custodial? Non-custodial. When might the interview transition from non-custodial to custodial? We'll talk about that tonight. Discuss when the right to remain silent would and would not apply, and then support conclusion with constitutional law, case laws. Okay, so make sure that you give me at least one. I've already told you. Reply posts. You can deal with one other student's post, okay? All right. I know you got that one. The one thing about this course, the way they set it up, is that the written assignments all coincide, if you notice that, with the topic. That's what I really like about teaching the topic, okay? Okay, so you got your live classroom submission, your recording, and then the topics we're going to discuss: the double jeopardy, right to remain silent, and we're going to look at procedural due process. Okay, so let's talk about double jeopardy. Whenever I teach this course, I cannot help but to talk about a movie that I know with Ashley Judd and was it Jamie Lee Jackson, I think that's his name. Did you ever see Double Jeopardy, the movie with Ashley Judd? Oh, you got to see it. You got to see it. You got to see it. Got to see it. But I have to talk about the plot in it to get my point here. But you'll see it. Basically, a woman is charged with killing her husband. Um, she's found guilty of murdering her husband and actually serves time in jail. And then she's about to be released on parole. However, while she's in jail and in prison, years had passed, she finds out that her husband was not dead, that they faked his death, and that he and, get this one, her best friend got together and got married. And they moved down to New Orleans, where she tracked him down. And when she got down there and found him, he had changed his name, and he was living a life. He had, made good money. How come? Well, his own insurance. So the point of the matter is that it was really something. The bottom line was, his name was Devereaux, I think, down there when he moved down there. She tracked him down and she confronted him, and he tried to kill her. Well, at the end of the movie, um, he was trying to kill him, her, and Tommy Lee Jones. That was his name, Tommy Lee Jones, and the parole officer. And she instead killed him. And so at the end, they tell her, they says, all of this belongs to you. She says, I don't want any of it. And so it says, well, you will not be tried, because she's already been tried. and served for the murder that really hadn't taken place. So when it really finally took place, she didn't have to. So it's a good movie. Go check it out. I like her. I like the Judge sisters. I like their singing. But you familiar with their singing? The Judge sisters, Ashley, yes. But Ashley is a great actress. Great actress. So anyway, the United States Constitution makes it clear in our criminal justice system that um, when a person is um, prosecuted or found guilty or even not guilty, they can't be tried again for the same offense. Now, the Fifth Amendment is what prohibits double jeopardy. Now, notice what it says. Nor shall any person be subject to the same offense to be twice put in jeopardy on life or limb. And the important thing that you need to be aware of is that that does not mean that you cannot be tried in the federal court and the state court. It means because there are two different systems, and you cannot. One of the things that you should be aware of is that juveniles, when an individual is a juvenile and they're tried for a criminal offense as a juvenile, you cannot be tried for the same offense as an adult. As Breed versus Jones, a 1975 case, established that quite clear. Once a juvenile is a judge delinquent in juvenile court, they cannot be waived and tried again for the same offense in adult court. That would be a smack dab in the face. And it finally says that double jeopardy is a fundamental right, like freedom of speech, freedom of religion, and Fourth Amendment right of search and seizures. It applies to adults and juveniles. So now we're going to talk about the next right, which is the Fifth Amendment right. So you can also look at, for double jeopardy, you can look at Benton versus Maryland, but Breed versus Jones is the leading case. It's the leading case, and incidentally, that's properly cited there. Or if you want a little bit more about what is double jeopardy, you can check that out as well. All righty. Any questions about double jeopardy? Now, most people have heard of double jeopardy, and then there's just for a moment here, you'll see this, and then we're going to jump into the next topic. Defining double jeopardy cases, the Palco case, and the Benton versus Maryland. So this has two cases that you can take a look at, and you can learn more about it if you want to. But I had mentioned those cases anyway. Let's get to the right to remain silent. You see that young lady with her hand up? What I like to do, my clients, is not that, is this. Not that one, because some words can get out. That's how, so, now, did you not know that nodding your head uh, does not necessarily mean that you have incriminated yourself? It could, but it would not. But it says you have the right to remain silent. Anything you say. So are you saying by nodding your head? There could be arguments. There has been some cases that argued that. And some say yes, some say no, but I still say no. But the point of the matter is that if you are placed into a situation where you are interviewed and it says, and you advise he is free to go home at any time, do you have to read the rights? Absolutely. Good call. Absolutely. You begin to attach the rights when an individual is in custody. In custody, does that mean that you have to say to that individual, you are under arrest? Do you have to say those words? Absolutely not. Absolutely not. Some students believe that that's the case. But the answer is you recognize that your liberty is taken away and you are not free to go. So, in other words, you are held captive. Okay. Now, notice this little piece here. It says, do I have the right to remain silent? What is your response? You have obtained enough information from the suspect to establish probable cause he is no longer free to go. Okay. Do Miranda rights now apply? During the interview, the suspect's mother arrives at the police lobby and demands the police recognize her son's right to remain silent. What will you tell her? Well, I wouldn't say he has to answer. I wouldn't say that. I wouldn't tell her that. See, you setting yourself a trap. I'd tell her, uh, please be quiet, or you have nothing to say about this. That's what I would say. But I wouldn't say that because you see, if you really think about the words that you use, then you're putting it out there that he has to say something. You don't want that to happen, right? Okay. Excuse me. That's why you have well-crafted words. I tell you the truth, boy. We defense lawyers, boy, we knew how to take them words and we would use them to our advantage. Even though you said, and then I heard a police officer say, "Well, what I meant to say, said it understand." Boy, I sat there like, wow, points for me. Well, doggone it, or I actually had one that he just started cussing on the stand, and I backed off. I didn't start asking any more questions. I said, no further questions, Your Honor. I sat down. Oh, buddy, boy. I know he was cussing my name for a long time. But anyway, um, most Americans are familiar with the phrase, you have the right to remain silent, from the infamous case of Miranda versus Arizona. And you have a right to an attorney. And then, it goes kind of like, you have the right to remain silent. Anything you say can and will be used against you. You have the right to an attorney. Do you understand these rights and that kind of stuff? And then it goes down. Most law enforcement officers are taught and trained not to do it from memory. When I was in the academy, even way back 89 to 93 was when I was a police officer, we were using a pre-printed card. And the reason why we used that pre-printed card is because of the fact that it was going to be quite clear that when you got to court, the defense attorney was going to challenge you. And if you tried to do it from memory, you could get nervous and say one thing wrong and throw it out. Bam, you can't retract it once you put it out there. It's out there and it becomes part of the record. So what we do is say, did you administer the rights to my client? Yes, I did. And what are those rights? Well, um, I have a prepaid card that I read to him. May I read from that card? Well, the defense attorney can't say no, never mind. No, he because the prosecution is going to come back around when they get a cross-examine and says, could you please read from that card? And you would read from that card and it would have everything right. And so you look at that, and that's one way of plugging up the hole from the prosecution side. So the infamous Miranda rights, uh, dealing with good old Ernesto, where he had provided a written statement and was convicted. Um, and the courts affirmed the conviction because Miranda never requested an attorney. The Supreme Court reversed and cited the advisement of Fifth Amendment rights were necessary, and the Miranda rights were born and have been applied ever since. And there are other parts of it too that came about when you consider, if you look at some one of the attacks or challenges, if you look at Dickerson versus the United States, and that was a case, I can't believe that's 21 years ago. Wow. I remember that because that was around the time I was retiring from practicing law when I was 50, which was 2000. But I do remember that case and how that was a chance that they thought they can cut into the rights. So it says very eloquently, when you are in custody, and it's an objective test and applied and hinges on the degree of restraint, a reasonable person would believe that they are not free to go. A person that says can be in custody without formally arrested for Miranda purposes for criminal offense and subject to interrogation. Therefore, if a person has been arrested for a criminal offense, but the police don't want to question them, then you don't have to give them Miranda rights. But common practice in law enforcement is to give them Miranda rights for a reason that someone might blurt out something and say something. Then you want to make sure that you can use that information. So the best training and best practice is to give it when the person is in custody. All right. So it says, fictional law enforcement stories often depict a person immediately reading a Miranda warning upon arrest. It says immediate advisement is unnecessary unless the police wish to question. Well, again, I was always taught, do it because you might decide to question them. All right. Now, but it's got to be related to what it is that you're holding that person for. All right. Questions unrelated to the arrest can be asked, such as booking or identification questions, things like that. Those are perfunctory things. But once a person is placed under arrest for a crime and the police wish to interrogate them, the Miranda warnings will keep it going. So failing to properly advise an arrested person of their Miranda rights can result in confessions gathered and being excluded via the exclusionary rule. You know that one, don't you? And the way that triggers is that we attorneys would file motions to quash the statement and exclude it, that it was taken in violation of the Fifth Amendment rights of that individual. There are a number of ways which that can be done. You can do it physically by forcing a person, intimidating a person into making statements. I've had those kinds of cases. More and more now, law enforcement have gotten pretty smart with it and use recordings of the interrogation so that the defendant can't come back and say that it was forced or beat out of them. I had many cases. And actually, to be honest with you, I actually had some cases that I was kind of peripherally involved where individuals, the statements were thrown out because the police, and this happened in Chicago, there was a infamous commander in Chicago. His name was John, Jonburge, and he has passed. And in his station, they became well known for having cases tossed out because they actually tortured individuals in the confessions. We're talking during a period of 80s, about the mid 80s, somewhere along those lines is when Burge did those things. Yeah, at the old, what we call Burnside Police District. But that happened in other parts of the country. So finally, with interrogation of individuals And if that person decides they want to remain silent, then you have to respect that. And you can't ask them, are you sure? It says, though, however, a suspect who voluntarily comes to the police department for questioning and is not under arrest can assert the right to silence until they are held in custody. So, in non-custodial cases, silence may be used as substantive evidence. As in the Salinas case, when the suspect invokes the right to remain silent, it must be clearly expressed. I said it, out of your mouth. Okay. Now, merely remaining silent is not an invocation of the right. You have to say, I don't want to talk to you. And usually you'll hear some said like, I don't want to talk to you. I want my lawyer first. That right there is adequate, right there. All right. The right to silence is a personal right and generally cannot be asserted on an arrested person's behalf. People versus Houston, State versus Corper. Those are some cases. Remember that from what you saw earlier about mom. Anyway, that's why I said tonight I'm talking about things that can help you in terms of, make this down. Remember this. The right to remain silent, along with the right to an attorney, must be provided to suspects who are in custody for a criminal offense and subjected to interrogation. Period. That's the, as they say, that's the alpha, that's the omega, that's the beginning, that's the end, that's the all in all. If you don't honor that, it can result in the exclusionary rule of being applied. All right. We're going to talk about procedural due process next. Any questions about this? Okay. I like it. It's pretty straightforward. You did a good job with putting this part together here. Just a review for yourself, which I'll quickly go touch that, is that Supreme Court cases, and I've already kind of given you a head start on that. Choose the correct answer. The next to it, which case established the right to remain silent? You already told me the answer to that, so yeah, there it is. And that's the leading case. Okay, you're correct. All right, one more. Let's do that. Which case established that an individual cannot assert the right to silence when being voluntary? Question. Okay, what you want to do? But it was actually Salinas. Remember, that's the one I started talking about that applies. Because it has to do with, really, it fits directly with what that kid's mother was trying to do. Excuse me. Let's do one more. I like these. Okay, all right. I got to submit the question. Which case established the merely remain silence is not an invocation of that right? You may not know that one. Sounds like it would be this one, doesn't it? A lot of people get trapped into that. That's because it says Arizona on it. But it's actually this one, you hit it right on the head. That's the case. That's the correct one. Okay. So anyway, you can go through those and it can help you out there in terms of a neat little tool to help you. All right, but you can get tripped up by that name, because I can tell you my students always pick the one. That's why I clicked on that one for Arizona, and they think, oh no, just because Miranda versus Arizona was the case. Nope, that is not the correct one. So let's conclude with procedural due process. So one of the important key factors in an individual in our criminal justice system is that you're innocent until proven guilty. All right. And it is so important that people understand that, even though, to be honest with you, in practice and application, it's actually the opposite. But it is written in the Constitution that only the guilty are punishment. Look at it, says, an innocent man is never convicted of a crime he did not commit. Yeah, right. Anyway, that's right. That is not true. Absolutely. That's what a lot of wrongful conviction case. Did you see the instance of the man? I can't remember his name. He was in jail 43 years, in prison 43 years for a crime he didn't commit in Missouri. And he was just released the other day with the help of the wrongful conviction program. I can't remember his name, but it was just on the news the other day. And I know it. They talked about he started in 1978. I said, oh wow, that's when I started practicing law, in 1978, after I graduated from law school, and that's 43 years from now. Anyway, you should not. And the bad part about that, guys, is that they had to do a GoFundMe page to help him. He got over $1 million the last time I looked at it. And Kevin Strickland, yeah, thank you. That's the name. And so, yeah, and I was listening to him being interviewed on CNN, and he was saying that he wanted to go see the lake. I mean, no, the ocean. He wanted to go see the ocean. And think about it. See, I think about this in terms of that. He was in there since 78. When I came out of law school, there was no technology. None. No World Wide Web. None of that stuff existed. And so now he's got to deal with that, and it's just a whole lot of things. And his mom passed away while he was in prison, and he couldn't go. So there are things that were taken away, and they have no monies that he's entitled to. Only time they did that is if he was freed because of DNA. But he had stronger evidence that even the prosecution existed later wanted to free him, but there was debates there. You can't. That's exactly right. Dollar amount. There is no dollar amount for freedom. I don't care how much money you get. Uh, you can't. It's gone. So in 1895, the Supreme Court said no man should be condemned on a criminal charge in his absence, because it was better to let the crime of a guilty person go unpunished than to condemn the innocent. That's a Coffin versus United States. That I always said that about the death penalty. Remember, just the other day, a young man down in I think his name was Julius Jones. I think that was his name, in Oklahoma. He was facing execution last week, and the parole and pardon board had said that they should commute his sentence to life sentence. And the reason why, with the possibility of parole, and the governor just sat on it and sat on it until hours before his execution, and then finally put him on, removed him from death row and life sentence without the possibility of parole. Well, it didn't matter, because the point of the matter is that what can you say to someone who has been executed, not to them, but to their family, that has been executed, and you find out that they didn't commit their crime. Oops. Just the same thing. I mean, here this person's life is gone, you know. So anyway, procedural due process ensures the rights, or at least attempts to assure the rights are accused. And just remember, justice is blind. If you see the statue, you know what I'm talking about. And it is the eyes and ears are the people in the system itself, the lawyers, the judges, the law enforcement people. And so in the Fifth Amendment is the due process clause, and the similar clause in the 14th Amendment. And it applies to all cases, state and federal, now since the 14th Amendment. And it's about, as we use the phrase, FF, fundamental fairness of the process, and that the framers didn't specify what constitutes procedural due process. That's interpreted by case law. So going down here, excuse me, you can go down and you can read quite seriously, going back to 1856, where it's a civil case that can result in a criminal activities. Well, this was actually a criminal case, but it could have been civil in nature, where the collector embezzled more than $1 million, and there was a warrant issued and so forth. And you go through and you can read that. But the fact of the matter is that, just a little history, due process is so important. The federal due process recognized in 1913. That's how, going back, the importance of discovery and cross-examination. Discovery is the first process that takes place. Some jurisdictions call it disclosure. After a person is charged, we lawyers file what we call a motion for discovery or disclosure to request the evidence that the prosecution has against our clients, and the prosecution has the responsibility of disclosing or sharing with us all the evidence that they have. And that information, if any of it's withheld, or what we call exculpatory, which is what happens in many cases, and that's part of the Strickland case. Exculpatory evidence is evidence that would favor the defense, and the prosecution knowingly withheld that. That could be grounds for reversal, because the individual was convicted in violation of the due process. All parties fully apprised of the evidence submitted must be given opportunity to cross-examine. That is, to question the witnesses, and that's what we do before court, and we do it after, to inspect documents and things in relation to the charges. So it takes place in a court, before a magistrate or a judge. The accused is entitled to notice of the actions and the grounds. That usually comes in the form of an information or indictment, and an opportunity to present reasons, that is their defense, against the actions. Right to call witnesses, and then of course, you know, the right to an attorney. A record of the hearing is made, and a written decision is given. And notice this one: public attendance. Why am I saying that? Okay, if you followed the Arbery case, the defense attorney said something was extremely stupid, extremely dumb, and I personally felt racist, is that he did not want Jesse Jackson or Al Sharpton or black pastors in the courtroom because it might influence the jurors. How? I mean, it's like everybody I know who practices law said, did that come out of his mouth for real? Yes, it did. It's a part of the record. And this is still a basis that they're going to use for appeal. It's a public place. That's what the judge said 2 or 3 times to the attorney. He also said that they were, and then when he did that, all those black pastors came together for prayer outside the courtroom, outside the courthouse. He said that that was a lynching. I said, oh no, that's not a lynching. They were praying. They weren't even rioting. So the point of the matter is this, that last statement, a public attendance. The only court that really doesn't have that is which one? That's right. That's right. That's right. But it is so important. Now I've seen courtrooms limited in terms of attendance because of the crowd and so forth and so on, and those kind of things. You know, like I did the O.J. Simpson case. I didn't go to California. I worked it on television here reporting I had 3 or 4 radio stations that I reported to after I looked at the tapes of the case, and I got paid pretty well for doing that as a commentator. So I did that as well. But the point of the matter is that only so many people could get in the courtroom, but you cannot. I have to go by what the jury said. I have learned as a professional, and you would learn that too if you ever become one in that area, that your answer is going to be, we don't. That's not my job. That is not my job. Somebody asked me once, and then I'm going to wrap up here, is that have I ever represented a guilty person? And I told them um, everybody I represented were presumed innocent. And then some were found guilty and some were not. But when I started representing them, they were cloaked with uh, the cloak of innocence until proven guilty. So the point of the matter is, I didn't do appeals. If I did appeals, then I would have to answer yes. So I did not, and it was out of my hands. I never, I can feel what I want to feel, but my job is to use the law in an ethical fashion, by the way, to defend my client and leave it to the trier of fact, whether it's the judge or the jury, which primarily my thing was the jury. So that's how I was taught, that's how I was trained, and it worked out pretty well. Okay, so um, friendly. If you do some research, you'll find out the justice friendly. That was a long time ago. Um, it says procedural outlines by Friendly in 1975 were written decades ago. And in contemporary due process hearings in front of a judge or a magistrate, and you can provide hearings, witnesses, and all those things, the right to an attorney and all that stuff. This was a descendant, H. Friendly, but there was a Justice Friendly that was not this person in 1975. He was long dead before that. So whenever I think of Friendly, I think about that justice. And that's it. Every state has their own procedural due process. However, the Supreme Court will let you know in a minute, if you go up there, that there's a superior. You cannot use the state procedural due process rights to take away the rights of individuals. Okay, so now you do the knowledge check on your own. But I just show you how it works again. Which amendment prohibits double jeopardy? Which one? There we go. Yeah, so correct. Sixth Amendment, right to counsel. Eighth Amendment, cruel and unusual punishment. Which amendment provides the right to remain silent? Yep. when somebody says they plead the fifth, by the way, like for example, before a congressional hearing or in court, then that's they're exercising their rights under the Fifth Amendment, and they don't have to say anything at all. Okay. Now, there could be an inference drawn by the trier of fact that when the person is exercising their Fifth Amendment right, that they're hiding something. That's true. But is it illegal to hide something? I don't think so. I mean, it might be unethical, but those kind of things. So anyway, I'm gonna let you go on that. All right. We have had our discussion, and now it's time for the question of the day, which is, yes, how about it? Yeah, okay, that's close, but give me a phrase. There we go. There we go. You were there. You were there. You were there. But I thought that from if you ever listen, if you go back and listen to the tape, you'll hear me emphasize that phrase. I did that purposely. Yes. Give me right to remain silent. Don't give me right. Don't give me remain silent. You won't get your points. You give me right to remain silent. That's the essential thing that we talked about today. Well, it's been a pleasure. I enjoyed this session. I really I have a lot of fun teaching this topic. Don't you find the topics that we have in this course very interesting? Yeah, I do. Like I said again, I love teaching this class. Now I do. They had it before. It was not so good, but they did an excellent job with this one because we're dealing with some real stuff. So, okay, well, I'm gonna let you go. I will see you next Monday at the same time. Um, uh, Thank you. I've already graded discussion posts for week 3 and in the process of grading my written assignments for week 3 already. And then if you have any questions about the assignments, which I doubt it, um, you know, it's really, really very good. All right. Okay, I'm going to say good night to you, Valerie. Thanks for coming out again, spending this time with me. And I'll say, go Bears. Okay. There'll be a lot of people in this class that are from Wisconsin that'll say, I'm not going to that class anymore. Okay. Yeah. Yeah, my man, Sweetness. Sweetness. Yeah, he's a class act. I could tell you story after story, hours, and sit down that I saw him do some generous things for people that he never knew. I mean, taking off his watch, a Rolex. Did you hear me? A Rolex watch. Person admired his watch. He says, "Here, this is a gift to you." He didn't even know the person. That's how Walter was. He was classy guy. And the last thing I'll tell you about him is that when he found out that um, he needed I think it was new kidneys, but liver. Yeah, they offered to move him up the list because of who he was. He told him, "I'm not doing that. You're only doing that because I'm Walter Payton." And he said, "I'm just not going to do that." And he didn't. And he turned that down. Class personified. As it turned out, it wouldn't have mattered because he had some other issues later with that. So, but anyway, God rest his soul. Jared, his son, is carrying on TV, doing sports on WGN, and his daughter Brittany is on Fox doing some stuff as well. He only had those two. So, yeah. Okay. Good night.